with a bang, I would say, and lots of people here. I appreciate it. But before we get started on the hearing of House Bill 2426, we have a little bit of housekeeping to do just with our committee. And so the first thing I would like to say is that we have a new member, which we're welcoming, Representative Sappington. Thank you for being here. I have a gift for you. If y'all would pass this down to her, please. This is the sentencing grid, which we use in the committee quite a bit. If anyone doesn't have your sentencing grid, you're not bringing it with you, I have a couple extras here if you need it. So, and it seems like that's something we're going to be dealing with. If any indication so far of bills that have been filed, we're going to be looking at the sentencing grid. So that's one thing. The next thing, just housekeeping. If you would like paper, testimony and paper, we're going to do a little bit different this time. I think paper is great. Some people want paper, but I would like for you to let Lene know, who's our committee assistant, and she will get with your office assistant to make sure that everything is there in time for her to print it, him to print it off for you so that you can bring paper. I mean, generally it's a little cumbersome for her to print off everything, but if you just must do that, that's fine. We can do it, but it would be better if your office assistants print it for yourself. So we can talk about that, and please communicate with Lene about that. Okay, the next thing, because we have a new member, we are just going to go around. We're going to do introductions. We do have one new member, at least of our revisor staff, and maybe we have a new IT person. So we're just going to go around and say our names, and we're going to start with you, Representative Bourgeon. And I would have given you the question in advance because you're going to be the first one to answer the question, and it's just a quick question. We're not going to comment, but I'm going to show you what the question is in just a second. I would have given it to you in advance, but you weren't here, so. Okay, so please just say your name so Representative Sappington knows who everybody is, maybe just where you're from. And the question is, especially like after we have this kind of hearing that's maybe filled with emotion and that kind of thing, or some other time when you have some stressful thing, what is your go-to comfort food? I didn't say drink. I specifically said food, not drink. So just if you'd introduce yourself, thank you.
Thank you, Madam Chair. Jesse Bourgeon, I represent the 52nd House District, which is southwest Topeka. And my favorite go-to food, maybe a good bowl of pasta.
Okay, Representative Sappington. You push your button, yeah.
Thank you. Representative Sappington from the 5th House District from Baldwin City. I would probably go to Oreos.
Representative Bob Lewis from Garden City. I would also go with a specific pasta, pappardelle with bolognese sauce.
Pam Curtis from Kansas City, Kansas, and my go-to food would be dark chocolate.
Jill Ward, House District 105 Northwest Wichita. I'd say mashed potatoes and gravy.
Mark Schreiber, District 60, most of Emporia, Northwest Lyon County. I would say coconut cream pie.
Charlotte Esau from Olathe, northwest part of Olathe. And gosh, I would like all of these, so I'll go with dark chocolate.
Dan Osmond, District 48, that's in Mid-South Overland Park in Johnson County. I'm going to shout out Taco Bell.
And Susan Humphreys in Wichita, and I represent part of Andover. And another fast food, I'm going with Popeye's fried chicken.
Representative Laura Williams, I'm from House District 30, which represents parts of Lenexa and Olathe, and I would pick Topped Pizza from the Lenexa Public Market. So.
Hi everyone, I'm Representative Lindsay Vaughn. I represent House District 22 in Overland Park, and my ultimate comfort food is homemade chicken noodle soup.
Hi there, I'm Lauren from House District 15, Lauren Bohai from House District 15, Southwest Olathe. And comfort food or like emotional food, if it's an emotional thing, then I would probably go for a quarter pounder with cheese from McDonald's. If it's comfort food, then I want like Cherry Garcia ice cream from Ben & Jerry's.
You're both good, fine, yeah.
My name is John Carmichael. I'm the state representative from the 92nd District in Wichita. And utilizing the chair's definitions, I have to confess that I generally don't eat food after a stressful hearing. If you ask me about beverages, I think you all probably know the answer.
Brad Barrett, state rep for the 76th House District, just south of here. I'd say cinnamon rolls.
Dan Goddard, District 7 from Parsons, Kansas. Those of you who are not familiar with the geography, my district is 30 miles west of the largest marijuana supplier to the state of Kansas, commonly referred to as Missouri. Yeah. And my county borders on the largest unfenced penitentiary in the world, commonly referred to as Oklahoma. My go-to food is popcorn popped on a stovetop with real butter.
I'm Angela Martinez, Representative District 103, Wichita, and I'd say Godfather's Pizza.
Representative Kyler Sreely from the 102nd District in the southern half of Hutchinson. My go-to would be Whataburger. It's not in Hutchinson, so I have to come up to Topeka or Overland or Johnson County to get it. So it's a one in a. It's not very often.
Good. Okay, and we'll go ahead. Let's go ahead and do. Lene, why don't we start with you? Mm-hmm. You would say your name and also what your position is. Yeah.
I'm Lene Hosek. I am the committee assistant, and my go-to food is whatever these people have given me and ends up in the bottom drawer of my desk.
Jordan Milholland with Legislative Research. I'm going to add another tally for Taco Bell.
Natalie Nilsson from Legislative Research, and I would say macaroni and cheese.
Mike Ditch, Legislative Research, cookies and cream ice cream.
I'm Tommy from Broadcasting, and I'd have to go with probably KFC.
Donica Short, Reviser of Statutes, and pasta too.
I'm Natalie Scott from the Office of Reviser of Statutes, and I would go with any kind of liquefied cheese. So like chips and queso, fondue, any of that will do.
Jason Thompson, Office of Reviser of Statutes, and dark chocolate.
Okay, thank you, everybody. Really appreciate that. And was it Toby? Sorry, I missed that. Tomy, T-O-M-Y? T-O-M-I, okay, got it. Okay, and you said broadcasting. Is that what we call your department now? Okay, okay, good to know. Thank you. I appreciate that clarification. Okay, thank you, everybody. It's fun to know. Okay, the last little housekeeping, just I think you got a list of the House Judiciary Committee rules on your desk. Nothing has changed as far as those go. We probably won't do anything really different this year than we've done before, but just so you have those. Okay, that's great. We will go ahead then and begin. I'll open the hearing. Yeah. Oh, thank you. Yes. Do we have any requests for bill introductions from anyone on the committee? Representative Osman.
Thank you, Madam Chair. I've got two bills for an introduction. The first one is 26 RS 2644. It would be for DUIs changing from non-person to person.
Okay, so without,
bill. Yeah.
okay, without objection, we'll go ahead and we'll do that request for introduction. Okay, thank you.
Thank you. The second bill is 26 RS 2645. It also relates to DUIs. It requires a victim impact panel to be attended.
Okay, thank you. And without objection to that one, we'll also request that for introduction. Okay, thank you. Are there any other requests for bill introductions from anyone on the committee or anyone in the audience? Okay, thank you. Thank you for that reminder. Appreciate it. We'll do bill introductions, requests for bill introductions the first thing every meeting. So, okay, now I will open the hearing on House Bill 2426. And I will ask our revisor, Jason Long, to be the one to come up and give us an overview of that. And you can tell us your go-to comfort food if you would like to, since you're
Thank you, Madam Chair, members of the committee. Jason Long with the Office of Revisor of Statutes. My predilections tend to fall more along with Representative Carmichael's when I've had a long day, so we'll leave it at that. House Bill 2426 makes various amendments with respect to the term gender as it's used in state law. Many of you were here in 2023 when the legislature enacted Senate Bill 180, which is known as the Women's Bill of Rights. That is now codified at KSA 77-207. And the Women's Bill of Rights establishes a definition for the term sex and directs governmental entities that collect vital statistics to identify individuals as either male or female at birth. And it made no other changes to state law. Around the time that it was enacted, the director of the Division of Vehicles for the Department of Revenue issued a statement that the division would continue to accept and process updating driver's licenses with respect to gender markers. The Attorney General filed suit challenging this action by the department and sought a court order directing the department to comply with the provisions of 77-207 and only issue driver's licenses that identified the individual by sex as it's defined in the Women's Bill of Rights. The Attorney General also sought a temporary injunction to prohibit the department from issuing any more licenses with changes to the gender markers as the case was progressing. The district court did agree with the Attorney General's arguments and issued the requested injunction. There was an appeal, and last June, the Kansas Court of Appeals reversed the district court, holding that the Attorney General had not met the legal burden to justify the issuance of an injunction. House Bill 2426 proposes amendments to various state laws to address the issues that were raised by the Court of Appeals in its decision. First, and probably the most prominent aspect of the bill, is the amendment to the Women's Bill of Rights itself. This starts on page 5, and the amendments actually appear on page 6 of the bill. It would add the term gender to the definition of sex. This would equate the two terms for purposes of the Women's Bill of Rights, and so both terms, sex and gender, would mean the same as the biological sex of the individual, either male or female at birth. The bill also makes a change in subsection C, where the collection of vital statistics directive is, and it would direct that governmental entities could only identify individuals in their records by their biological sex at birth. No other recording would be permitted with the word use of the word only in that provision. Second, the bill addresses the Court of Appeals holding with respect to the term gender as it's used for driver's license purposes. The bill amends two statutes under the Driver's License Act. One is to define gender under those statutes to mean the same as it's defined under the Women's Bill of Rights with the amendment we just talked about. The other would amend a statute to direct the department to notify drivers that their license needed to be surrendered so that it could be reissued with a corrected gender identification for the individual so that the gender reflected on the license matches the definition of gender as it's defined under the Women's Bill of Rights. The third amendment the bill proposes is to Uniform Vital Statistics Act. This is a new section of law. You'll see it on page 1 of the bill that would be incorporated within the Uniform Vital Statistics Act. And it would direct the state registrar to issue corrected birth certificates for any birth certificate that had been issued where the gender of the individual did not comply with the definition of gender as it's defined by the Women's Bill of Rights. And then finally, the bill makes an amendment to the Help Not Harm Act. And this is to the definitions section 65-28, 137, section 4 of the bill. It removes the term gender from the definitions section so that the act would only define the term sex with respect to that act. All other references to gender throughout the other statutes in that act are left in, which is generally just a reference to perceived gender. Just the definition of gender is being removed. These changes would go into effect on publication of statute book, which is July 1st, 2026. And with that, Madam Chair, I'd be happy to stand for any questions.
Okay, thank you so much, Jason. Does anyone have any questions? Representative Carmichael and then Vaughn.
Thank you. Mr. Long, usually we have a brief from the revisor's office on a bill. Do we have a bill brief from the revisor? I can't locate any testimony for this hearing. You have a copy. What about the rest of the?
It's on the S drive is what I've been told.
On the S drive.
I'll give you a minute to see.
I don't even know how to use the S drive. I'd have to have my office assistant.
Okay, we could probably make some copies for you. Would that be helpful?
Would be extremely helpful.
Okay,
And I understand there's a lot of
she'll go make some
testimony here and that you need to condense it and edit it before it gets posted. So I understand, but at least the revisor's brief would be very helpful.
Okay. We'll get some copies made. Right. She'll figure out how to get them. Okay. All right. Representative Vaughn.
Thank you, Madam Chair. Thank you, Mr. Long. So you brought up the Kansas versus Harper case. I just want to make sure that the committee kind of has the full scope of the opinion of the Court of Appeals. So you talked about how they opined and rejected the Attorney General's inaccurate conflation of the term sex and gender, but in reading the opinion, it also rejected his argument in the district court's finding that there was evidence, any evidence beyond mere speculation, to support a finding that law enforcement would be immediately hindered in its duties if the driver's license did not display the driver's sex assigned at birth. Is that correct?
I believe that is a part of the opinion. I'd be happy to provide a complete copy of the court's opinion to the committee for their perusal. I only have highlighted the portions from that opinion that were relevant in terms of the amendments proposed by the bill.
Thank you. I think that may be relevant to testimony, so I just wanted to highlight it. And then just to confirm, was that opinion by the appeals court upheld by the Supreme Court?
There has been no further appeal to the Supreme Court of that Court of Appeals decision, to my knowledge. So I think the matter may be back with the district court at this point, but I'm going to defer to the Attorney General's representative on any of the procedural nuances of the case, as they're more familiar with that than I am.
Okay, thank you.
Okay, Representative Osman.
Thank you, Madam Chair. If it's appropriate, I've got a question actually not to the revisor, but on the agenda itself. Under opponents written only, it says approximately 240 pieces of testimony will be condensed and posted as soon as possible. I'm unfamiliar with what it means to have testimony be condensed. Can someone help explain that to me?
Lene, our committee assistant.
I'm Lene Hosek, Committee Assistant. The best way to post that much testimony on the website is for us to condense it so it's 4 pieces of testimony per page. So that's a huge undertaking and not something that I could have accomplished before the meeting today.
Representative Osman.
Understand, thank you. So no actual testimony will be parsed from this. It will be the complete full testimony of each of the individuals. Okay, thank you. And I understand the committee assistant has been working as hard and as long as possible to get these up in the time period that we've had between the time that we've announced this as a hearing and had the hearing. But do we have an indication as to when those pieces of testimony will actually be available for us as a committee member and the public?
Hopefully by the end of the day tomorrow.
Thank you very much.
Okay, do we have any other questions, especially for the revisor? Anybody? Okay, Jason, thank you so much. And you're going to be here just in case somebody, great, that sounds great. Okay, with that, we are going to go ahead and begin the proponent testimony. First, I'd like to ask Attorney General Chris Kobach to come up. And committee, I do intend to ask questions for each conferee at the time they speak, just so you know, because there's a couple on WebEx that can hang on for a long time. So that's what the plan is. If it gets to be that we're just taking up too much time, we may have to ask questions at the end, but we'll begin this way. I hope we can continue. So, all right, thank you for being here. Welcome to committee.
Thank you. And hello to everyone. Welcome back, and looking forward to another great session. And we'll see you on other issues in this committee as well. And I want to thank the chair and the members of this committee for addressing this particular bill so quickly. I'll keep it fairly short. I know you have a lot of questions. So as you're well aware, and as the revisor mentioned, in 2023, a supermajority of the Kansas legislature passed SB 180 over the governor's veto. It did go to litigation. The Court of Appeals issued a ruling that, to put it frankly, defeated the intent of SB 180. And in the wake of the Court of Appeals ruling, SB 180 does nothing. It has no practical effect on anything in terms of the operation of Kansas law on Kansans. And so what this bill does is remove the wiggle room that the Kansas Court of Appeals seized upon, and which the district court properly rejected, and simply clarifies what the obvious meaning was all along. And so it's, you know, I'm sure there will be people who want to debate the merits of SB 180 all over again, and that's not really my job. I'm just simply explaining what we did in court, what the court did, the Court of Appeals specifically, and then I'll walk you through as to how this will remove any ambiguity, because courts oftentimes see ambiguity in statutes, and no statute is perfect, and sometimes you can't remove ambiguity because of the nature of the subject matter. But in this particular case, the Court of Appeals, I believe, twisted the ambiguity to create a meaning that renders the law a dead letter. And I don't think the legislature's intent was that. It's clearly it wasn't. And so this bill tries to restore the original intent. As was mentioned, the case in Kansas versus Harper was the case litigating this. I personally argued the case in district court where the state prevailed and held that the department was violating the law, KDOR was violating the law when it continued changing sex markers on driver's licenses. But all of that changed when the Court of Appeals issued its decision on June 13th of last year. And in it, the judges seized on any ambiguity they could find to come up with a position that, no, the law doesn't actually change anything with respect to driver's licenses, and birth certificates are the other significant documents that are affected by the law. And I think the best example of this, the court's reasoning, is a reference to the final page of the bill before you. Actually, it's the second to final page, because the final page has just a short phrase on it. But you'll see there that this bill adds the word only to subsection C. It adds the word only, one word, to the whole section. Why in the world do we do that? Because the way the bill is added, the way you read that sentence without it, any state agency that collects vital statistics shall identify each individual who is part of the collected data set as either male or female at birth. Any person familiar with the English language would say, oh, that's the way you identify them. That way, not another way. But the Court of Appeals, and I'll quote, said, well, nothing prevents KDOR's data set from both identifying an individual as male or female at birth and identifying them differently on the physical driver's license, end quote. That's at page 707 of the court's opinion. And for Representative Vaughn, I have the whole opinion here and be happy to address anything they say there. So I think most people would say that is a rather absurd reading of the statute. Unless you say only, then a direction from the legislature to refer to people by biological sex at birth means nothing, because you can refer to them both ways, and you can choose, you the agency, can choose which ones you want to put on the document, which ones you want to just have in your data set, but not put on the document. And so that's an example of what the Court of Appeals did. There were other opinion errors committed by the court. I won't go through all of them. But our agency hoped, and this also addresses something Representative Vaughn asked, our hope that the Kansas Supreme Court would address the issue, and we did appeal to the Kansas Supreme Court asking for review of the Court of Appeals opinion. However, on September 29th, 2025, the Kansas Supreme Court took the highly unusual step of declining to review the case. Think about all the other controversial cases that have, during your tenure as legislators, that have gone up. I can't think of a single one where the Supreme Court said, nope, we're not going to review that one. And think of Hodes versus Nauser, think of any of the school finance bills. The court takes them and takes them on a temporary injunction. Does not say, oh, let the lower courts deal with this for a few more years, we're not taking. But anyway, for whatever reason, they took the unusual step of declining to review the case. As a result of that, on October 8th, 2025, the temporary injunction, or preliminary injunction, sometimes federal term for it, the temporary injunction was lifted, and immediately KDOR began changing driver's licenses again. They haven't indicated to us what the total number is, but our guess is it's probably in the hundreds. And so what this bill does is restores the original meaning of the statute, and the meaning that we believe this legislature intended, and also reverses any licenses that have been changed in the interim since October, mid-October to the present, or whenever the bill is passed. And furthermore, it clarifies another mistake that the Court of Appeals made in saying that gender and sex have two different meanings in Kansas law. And I'll quickly address that issue as well, because in addition to adding the word only to the final section of the bill, and that may be the single most important word in this entire bill, the bill also makes clear that in Kansas statutes, sex and gender have always been used interchangeably. Now, today, in the midst of the trans issue and the controversies that surround it, sometimes people have taken to use those words as referring to different things, as gender referring to a subjective mental assessment of what one is. But in Kansas statute, for at least the past 50 years, the two terms have been used simultaneously. Many of you who are as old as I am will remember that back in the, say, 80s, 90s, 2000s, it was considered a little bit impertinent or maybe a little rude, a little uncomfortable to use the term sex in a law, or to use the term sex in conversation, because people would think, oh, you're referring to something else than just biological characteristics. And so the legislature, many, many cases, used the term gender, which was seen as a more socially acceptable way of saying sex. And so just to give you a couple of examples of this, KSA 6710A3 states that gender, eye color, and other traits are determined at fertilization. Clearly, a subjective state of one's person is not something, it's referring to biological sex. Another example, 6726 prohibits abortion based on the sex of the child, and is titled Abortion Based on Gender Prohibited. KSA 48292, which deals with insurance premiums, says you can't have varying insurance premiums based on a person's gender. Clearly, they're not, insurance companies aren't asking you what your subjective view is of your personal, they're talking about biological sex. So anyway, it just clarifies that as far as Kansas law is considered, the two terms mean the same thing. And that is another thing that the court seized upon. Why did they seize upon it? Because in the context of driver's licenses, our statute originally said sex, the Kansas law, and in 2005 it switched to the term gender. Why? Because Congress passed the Real ID Act and said that driver's licenses have to say all these things and have to include all these things. And the federal law uses the term gender. So this body said, okay, we'll match federal law and use the term gender. But get this, if you pull out your driver's license right now, it doesn't say gender, it says sex. So KDOR has been using the two terms interchangeably. Sex and gender mean the same thing. So all we do is we say, the court can't, for convenience of its decisions, say, well, we're gonna pick gender and call it something separate. Kansas law has always been clear, they mean the same thing. In common parlance, maybe that will change over time, but for now, for interpreting the statute, they mean the same thing. So that's a quick summary of what it does. All it does is clean up any possible wiggle room in the bill. I think the legislature did a fine job in passing it. And absent judicial activism, we wouldn't be standing here right now. But because of what the Court of Appeals did, and by activism, it's not a derogatory term. Well, it is somewhat derogatory, but it's where a court steps out of its judicial role and acts in a legislative capacity and says, we are going to act to change or add meaning to a statute. That's clearly what the Court of Appeals did. And we're simply trying to help the legislature control the meaning of law. If you don't want to control the meaning of law, then let the Court of Appeals decision stand, and the courts can change what you have passed. So with that, I'll take any questions you have.
Okay, thank you. What questions do we have for Attorney General Kobach? Representative Lewis.
Yeah, just a sort of a question about the procedural posture of the cases. It's my understanding, correct me if I'm wrong, but this was on a preliminary, what I'll call a preliminary injunction or temporary injunction motion. So there's been no final decision from any court in the state on these issues, has there been?
Correct. And so what often happens is, you have a temporary injunction, and then the Court of Appeals will do a first crack at defining the meaning of the statute, which the district court had to do as well. And they said, oh, we don't see the state as likely to prevail. That's the standard. Are you likely to prevail on your version of what the statute means? So it did go back, and because the Kansas Supreme Court didn't take it, it then went straight back to the district court where it's on the final merits. But typically, the district courts will feel obliged to follow the decision, even though it was on a preliminary stage that the Court of Appeals made. But the case will still be argued. And, in theory, we can convince the Court of Appeals the second time around to change its mind. But, it's pretty clear to me that it was defeating the intent of this legislature and clear to every attorney in our office looking at it. And so therefore it would be simpler to just, and I think this brings up a good point, by defining it clearly now, so these terms, adding the word only, it'll end the litigation, and we will no longer be spending hundreds of attorney man hours on this and clogging the court's docket as well with this, very litigious issue.
Representative Lewis, go ahead.
Yeah, just to follow up, we're talking months or years before this would finally get resolved, perhaps by the Supreme Court.
If we didn't have the...
Right, if we didn't
Correct.
step in now.
Yeah, I think at a minimum, it would take 2 years and probably longer than that. By the time we have a new decision of and then a new decision of the district court, new decision of the Court of Appeals, and then finally a decision of the Kansas Supreme Court, which they again may say that we don't want to take it. They have that option. So I think it's important to note one other thing. The Kansas Court of Appeals did something I have never seen them do. They said that the case will go back to the district court, but it didn't want that Judge Watson, to decide the case. It's truly bizarre. It suggested that she was somehow biased because she had rendered an opinion, but rendering an opinion is what you have to do. So that too is very odd. We had appealed that decision to the Kansas Supreme Court. You don't just, Kansas Court of Appeals just can't, administer a slap to a district judge and say, yeah, we don't like your opinion, we're going to give it to somebody else. So it was odd for a number of reasons.
Any other questions? Representative Carmichael.
Thank you, Madam Chair. Always a pleasure to see you, Mr. Attorney General. Following up on Representative Lewis's questions, I guess I have to admit, I don't know as much about this case as you. This bill was only introduced yesterday, and I've barely had a chance to read it. And of course, the Court of Appeals decision is some 56 pages long, and I'm sure you've read every word of it, but I will confess that I have not. But as I hear your description of the procedural history of the case, I can't help but refer to page 6 of the slip opinion. It is 3 paragraphs into the principal opinion where the court found because we find the AG has failed to establish irreparable harm to support the issuance of a temporary injunction and has failed to show a substantial likelihood that he will prevail on the merits, we reverse the district court's order and lift the temporary injunction. We find it unnecessary at this stage to address any other issues the parties raise. They will be resolved by the district court on remand. Did you present evidence of irreparable harm at the district court that the Court of Appeals just ignored? And if so, what was that evidence?
I'm so glad you brought that up.
I'm trying to help.
Thank you. That was one of the most astonishing parts of the Court of Appeals opinion, because we did present evidence of irreparable harm. For those of you who are wondering and are not familiar with preliminary injunction, temporary injunction cases, in addition to showing that you're likely to prevail, at the end of the day, you have to show some irreparable harm as to why the court should act now and enjoin what's going on. And we did. We presented evidence from law enforcement officers, both from Shawnee County and Johnson County, indicating actual examples of where people who had an arrest warrant out for them had attempted to either change the sex or appear to change the sex or taken steps to, so the arrest warrant is out for a male to hold themselves out as female. And this was true both in traffic stops and in executing arrest warrants on a residence. And when an officer pulls someone over for speeding and has to decide, is there a warrant out for this person, the first thing they go to is the driver's license. And the driver's license has to be accurate and reflect the driver's license, the older driver's license in the officer's database. And so that was one. Another one was in checking people into, when they are arrested and they're put into custody, one of the first things they do is decide, does this person go with the females, if it's a larger, say, Johnson County custodial facility, or does it go with the person go with the males? That too was one where the driver's license is used as the first indicator of a person's sex or gender. Later, if the person's held longer, they will obviously be removing the person's clothing they came in with and providing other clothing. Anyway, those are the two primary examples. There's also extensive evidence in Kansas case law that when the legislature itself, the state has an interest in the law itself being enforced. And so there's irreparable harm when a law's meaning is disregarded or set aside.
But of course, the Court of Appeals.
So did you have a follow-up question?
Yes, I do.
Okay, go ahead.
Actually, I'm trying to limit myself to the general two-question concept.
Great.
And I can certainly ask him my second question, or I can wait for Mr. Stewart, as you prefer.
You can ask each conferee 2 questions if you would like.
Thank you. So I take it we're just not going to be in agreement, or you're not in agreement with the Court of Appeals when they said, number one, you didn't present evidence of irreparable harm, and they went on to say that your opinion that there is irreparable harm is not evidence in the case. They just, in your view, just completely ignored that testimony that was presented. The Court of Appeals ignored it, and the state Supreme Court didn't grant review, and you haven't gone back to court yet to present the new evidence that was, you were given that opportunity in the court's opinion on remand to come back and try to fix your record, but you haven't been back, have you, sir?
I am telling you that the court is factually wrong and stated something clearly false when it said we did not present evidence. It was the testimony of Sheriff Brian Hill in Shawnee County, and it was a testimony of an officer, a corrections officer in Johnson County. His name escapes me, but it's all in the court record. I encourage you to look at the court record, and you will see that testimony from law enforcement officers where the court said they don't think that my opinion can generate irreparable harm. That was in reference to this. There is case law saying that when a state's laws are being violated, that's irreparable harm to the state. And the
court rejected that contention, didn't they, Mr. Attorney General?
Excuse me?
Okay.
The court rejected that very contention, did they not?
A court of appeals rejected the notion, yeah, that is the Supreme Court had established.
By the Supreme
Okay.
Court. Thank you, Madam
Are
Chair.
there any other questions from committee members for Attorney General Kobach? Okay, thank you so much.
Thank you very much.
Okay, next we will have Dr. Richard Bossart, and he is going to be joining us on WebEx. He is with Do No Harm Action.
Can you hear me?
We can hear you. We can't see you. There you are. Okay. Thank you so much. Welcome to House Judiciary Committee today. Thank you.
Well, thank you. I'm very glad to be
We
here.
can barely hear you. Is there a way to turn up your volume?
I've got it up as high as I can. I can
Okay.
speak louder. Is that better?
Nope, we can hear you now. Thank you.
All right. Thank you. Well, I appreciate being here. Chairwoman Humphreys and members of the House Committee. My name is Richard Bosart. I am a senior fellow for Do No Harm. I don't know if it's germane, but can I give my comfort food?
Absolutely.
It happens to be pizza. With that taken care of, I want to thank you all for allowing me to be here and provide proponent testimony for House Bill 2426. I apologize for reading from my notes. I am not a great public speaker, and I don't rely on my memory to get my facts straight here. I have been a medical doctor in practice for 47 years. Until recently, there has never been a serious question regarding the existence of two and only two sexes, male and female, as one of the most fundamental biological facts. All disagreement and controversy regarding sex and gender identification stems from a single source, which is belief. In no other instance does belief trump physical, physiological, and genetic facts. There is no third sex. There is also no such thing as a trans man or woman. There are only men and women who believe that they are the opposite sex, yet in whom every cell in their body is of the sex they were born into. Another name for a strongly held belief is a delusion. In medicine, we treat pathology, whether physical, psychiatric, or psychological. We do not affirm delusional thinking, but rather treat the delusion with compassion and competent therapy, while maintaining a firm grip on reality. This is true for such conditions as anorexia nervosa, body dysmorphic syndrome, and body integrity disorder. That this is not true for gender dysphoria reflects the fact that this condition has been hijacked by an ideology which has an agenda which transcends biological reality. Once upon a time, sex and gender were synonymous. This is no longer true. Today, gender usually means gender identity independent of a biological sex. Given that we now have more than 70 genders and counting, this has muddied the waters in discussing biological sex. To be clear, there are only two sexes, and a person cannot change from one to the other. Gender-affirming care produces a permanently medicalized individual whose conformity to the opposite sex is superficial, imperfect, and subject to potentially disfiguring and debilitating complications. That we have to have legislation and laws to affirm the basic truth of two sexes speaks to the confusion of our times and subservience of biological reality to a radical gender ideology. The commonly used expression, sex assigned at birth, is factually incorrect. The sex of a person is established at conception. That can be easily confirmed at birth by a simple physical examination, which is 99.9% accurate. In the very rare case of ambiguous genitalia, sex can be established very quickly with a simple test or a couple of tests. This is critical in medicine because there are conditions unique to men and women, and to ignore these invites potential mistreatment. No less than in medicine and medical documentation, an individual's sex and other documents, such as legal documents, contracts, identity papers, and more, must be coherent and consistent to be useful and prevent errors and confusion. Since the birth certificate is the original and most fundamental document confirming birth sex, or should be, then all subsequent documentation should be in agreement with this. Competent adults desiring to change their sexual identity should, of course, be free to do this if they wish. But this does not change their biological sex. A man cannot become a woman or vice versa. This is critical for no other reason that there are medical conditions unique to each sex, and proper diagnosis and treatment might not be undertaken if the official identity papers do not align with the biological reality. This would logically include a driver's license or an equivalent personal identity card. I thank you for the opportunity to be here and present this testimony in support of House Bill 2426, and I invite any questions that the committee may have.
Okay, thank you so much. Committee, do you have any questions for Dr. Barsart? Representative Osman?
Thank you very much for your testimony, Dr. Bozard. I believe you're a board-certified plastic surgeon, is that correct?
That is correct.
You might be able to help me to understand your medical experience versus the legal definitions that are being that are put into this document or this bill. So sex, in the bill itself, sex refers to the biological indication of male or female, including external genitalia. So if somebody is born with both male and female genitalia, what sex are they?
That is something which can be established by a couple of tests, as I mentioned. Typically, they will look at the genetic karyotype of the individual to determine whether they are a female or male according to their genetic makeup.
Okay. The definition also describes things like reproductive potential. So I don't know if that means that somebody with menopause who no longer has reproductive potential is categorized under sex, or if somebody that's born without a vaginal canal or without ovaries and a uterus, do they have a determination of sex under this definition in the bill?
I'm not here to render a legal opinion, so I'm a little hesitant to say anything which would smack of a legal opinion. I will say that from a biological and medical standpoint, that sex is well established at the time of conception by the union of the sperm and egg, providing for the genetic material. Yes, there are errors of genetic combination. You have XXY and such. Those can almost invariably be identified as a male or female, again, by simple testing and by the combination of testing and looking at the reproductive organs of that individual. To say that a person who cannot reproduce does not have a sex, I think that's an argument that I would not want to try to make. If a woman has her uterus removed for cancer, does she cease to be a woman?
Thank you very much. I'm not necessarily looking at, I was merely trying to determine, I realize you're not a legal scholar, but trying to interplay what the medical community might think of the actual language in the bill. And so thank you very much. I appreciate your comments.
Committee, do you have any other questions for the doctor? Representative Carmichael.
Thank you, Madam Chair. And Dr. Bassard, I have to apologize to you as well because this bill only having been introduced yesterday, I haven't had a chance to see or read your testimony. So I apologize if I ask you questions that may well be covered two questions that may be covered in your testimony. I understand you're a plastic surgeon, and it says that you are a visiting fellow at Do No Harm Action. Can you tell me what and where Do No Harm Action is, and is that where you perform your plastic surgery and practice medicine? If not, tell us where you do.
I am a retired plastic surgeon who practiced for 36 years in Central Florida. I just retired about a year ago.
Congratulations.
Excuse me?
I just said congratulations. I retired 2 years ago. It's a wonderful thing. Thank you. Go ahead.
I highly recommend it. I am actually a senior fellow with Do No Harm. I was elevated after having been a visiting fellow for a number of years because of my ongoing support of the organization. Do No Harm is based, at least at the present time, out of Virginia. It is the Do No Harm Action is a political arm of Do No Harm, which has evolved in such activities as what I'm doing today, which is to provide expert testimony and in the case of some sort of legislation. I'm not sure if that answers your question. If you want something more detailed than that.
So would it be fair to say that you no longer practice your specialty within the field of medicine? You no longer treat patients, but you do go around testifying as an expert witness on behalf of Do No Harm Action. Would that be accurate?
I'm not sure if the term expert witness is necessarily correct.
Oh, I thought you described yourself that way, sir.
I am an expert.
That's what I heard you say.
Yeah, I am an expert in the sense that I'm a medical doctor and I do have a long long-term career as a practicing physician. I don't provide extra testimony, for example, in things like litigation and malpractice and that sort of thing. I'm providing an opinion based on my expertise as a physician and my experience as a physician.
Okay. I don't want to go any farther with this. He's obviously giving an opinion today as a quote expert. Thank you, Madam Chair.
Do we have any other questions for the doctor from the committee? Okay, thank you so much for being with us. We appreciate you coming.
Glad I could do that.
We will now hear from Bob Stewart with the KBI. Welcome to committee for your first time this year, maybe others. Welcome.
I think I'm on now, yes. Madam Chair, members of the committee, welcome back to Topeka. My name is Bob Stewart. I'm the Executive Officer for the Kansas Bureau of Investigation, and I'm here to testify as a proponent on behalf of the KBI regarding House Bill 2426. I understand that you may not have gotten a chance to read my testimony yet. I was planning on just sort of summarizing a couple points, but I will spend a little bit more time going into all the points. They all revolve around one particular issue, and that really is accurate identification of the people we come into contact with. Everything involves that law enforcement is concerned about is specifically that. And mandating accurate biological sex markers is certainly part of that. We feel like it falls into 5 areas. First, accurate identification. Second, as it involves our activities in search and frisk activity, or when we make first contact with subjects or witnesses. Custody handling, database integrity, legal clarity, privacy in single-sex spaces, and emergency response accuracy. I am going to just focus on 2 of those, though, with you today, and that is law enforcement safety and subject safety when we first contact them in those situations where we're going to detain them or we're going to search them and frisk them. Everybody that's in law enforcement, every single one of us that have made arrests, understand that that's a high-tension situation. For us, it's not necessarily so much because it's what we do and we train for it, we practice it, we've done it a lot. For many people, though, it's the first time they've had that kind of immediate and intimate contact with law enforcement. It's close, it's personal, it's intense, it's emotional. And one of the things that law enforcement is, particularly these days, trying to do is trying to de-escalate that. Now, imagine those situations where we begin to do things like, quote unquote, misgender somebody, or when we start to treat them as a male when they believe they're female, or when a situation occurs where they're neither of those things. They're not gender confused or gender oriented in a different direction. They're merely trying to mislead law enforcement. They're trying to not get arrested today. And they'd lie to us. I know it's a surprise. Oftentimes when we try to put handcuffs on somebody, they say, it wasn't me, I didn't do it, you've got the wrong person. Not having correct identification, not having the right sex on a driver's license is one of those things that makes it more difficult for law enforcement to do their job correctly and to do it safely, not only for law enforcement, but for the subjects that we're trying to either arrest or clear and let go on their way. So that's the problem that we are most concerned about. Secondly, from the KBI's perspective, as of course you know, we're charged by you with maintaining all of the law enforcement databases in the state of Kansas and for providing the linkage to databases in other states, the federal government and foreign governments. That's through the a various number of systems, but all those systems, one of the base identifying pieces of information is a driver's license. Having correct information on that driver's license is important, not only for database integrity, but for how we share with other states, other countries, our federal partners. If we don't have accurate identification capabilities, then we can't make good decisions on the scene. We can't make good decisions when we're making arrests or when we're even writing warrants about what we need to do. Why does that matter? It matters, as I mentioned, for officer safety. It also matters for the things that we've talked about in other sessions when I've been here. We talk about identity theft. We talk about fraud. We talk about the ability of law enforcement to track down the people that we need to track down and arrest. And without valid identification capabilities, that's hindered. That's kind of the summation of what I want to talk about. I will briefly mention the others. Custody handling, certainly important. We talked about de-escalation. Certainly in all the institutions, both if I make an arrest as a KBI agent or when we're transporting somebody to a jail facility or holding facility, knowing what their sex is part of the determination about where they get placed. It's part of the determination about how we handle them. It's part of the determination about how they get physically searched. Certainly as a woman, they oftentimes prefer to be searched by a female officer. Males, maybe not so much, but most of the time we search them with a male officer. That's in policy, that's in training. And again, that goes back to de-escalation issues and making sure that we're trying to be as safe, not only for ourselves, but for the people that we're handling as well. The other two areas, certainly there's clearly a legal clarity issue here that we believe needs to be resolved. One of the things that our law enforcement partners get called out to on a more frequent basis are complaints about who's using bathrooms. How do we handle that situation? If we don't have clarity by way of driver's license identification, who knows what sort of situations we could start to get involved in and have been getting involved in as we deal with privacy in single-sex spaces becomes more and more of an issue. And finally, as you know, Director Mativi in his former life was a paramedic, and he will tell you that sometimes medical treatments are based upon the sex of the patient. Drug mounts, how you handle certain situations is certainly important. So for law enforcement as sometimes the first medical responder, and then paramedics who also follow on shortly thereafter, having accurate identification is important to the safety of the person that they're trying to render medical aid to. With those observations in mind, we are a proponent of having this accurate identification capability and stand for this bill. I will stand for questions should you have any.
Okay, thank you, Mr. Stewart. Do we have questions from the committee? Representative Carmichael and then Vaughn.
Thank you, Madam Chair. Since Director Matavi is not here, I don't think, at least, I'm not going to try to ask you about what he learned when he was a paramedic a literal lifetime ago. For he and I were about the same age. But there are at least two things that you said here that concern me. The first is that apparently you believe that if we put a gender identifier on somebody's driver's license, that comports with what they were at the time they were born, the way they looked, the genitalia that they had, etc., that would assist you or law enforcement in classification of prisoners, so which would be better for the prisoner. Now, I want to give you an example of one of my constituents. He was born female. He has gone through transition. He is in his 40s. He has a black, hairy beard. He is, by all appearances, a man. How would putting an F on his driver's license help you out? Do you really want to put this hairy-faced man into the correctional system with women? Is that what you propose?
It helps make the correct decision.
Okay. The second question then becomes, same general example. Putting an F on this man's driver's license because he was, quote, born male, unquote. If you look at his picture, you stop him on the road, he gives you his driver's license. He's a hairy-faced man. That's what shows on his driver's license. That's what the officer sees in front of him. Right now, his driver's license says he's an M, and it all fits together, and you know you got the right guy. How in the world would putting an F on his driver's license to describe this hairy-faced man as a female help you figure out that you got the right guy?
I would give you the same answer. It helps make the correct decision.
That's the best you can do, Bob. I guess that's the best you can do. Thank you, Madam
Vaughn.
Chair.
Thank you, Madam Chair. I have questions along kind of the same line. So in regard to the Attorney General's opinion, the appeals court decision in regard to the Attorney General's argument of irreparable harm, they found it inadequate because there was no evidence whatsoever that potential confusion about a person's gender prevented identification or arrest of that individual. There was no evidence whatsoever that that has ever happened. So I'm wondering if you can provide any evidence that is the case. I'm doubting that it is, and if it is, I would question the quality of your officers. You know, why can you not identify someone based on their picture, based on their driver's license number, and based on their name? Why do you need to know their gender? And that would be my first question. Thank you.
Well, I would agree with what the Attorney General said, which is that evidence was presented at the district court and the appellate court disagreed with it. So I would stand on that. But I can give you personal experience of dealing with, at the time, it wasn't somebody that was transgender, but it was somebody that was a cross-dresser, and trying to figure out whether that person at the time was who they said they were was very difficult. Now, it certainly gets more complicated when you add emotion, when you add sexual, opinions about oneself, when you add actual biological changes by way of surgery. That makes it far more complicated, which leads me back to my answer that I gave, apparently, without too much merit to Representative Carmichael, which was the better sets of data we have, the better decisions we can make.
I would argue that someone's civil rights are more important than whatever data you may have. And I guess my second question then is, what if I changed my last name and that name was not reflected on my driver's license? Why is that any different?
You're required to change it.
But if I hadn't had the opportunity to do that, would you still be able to identify and arrest me if it hadn't yet been changed?
It would make it more difficult. We might make a wrong decision.
That
We might
sounds
mistake
unlikely.
you for somebody else. We might arrest you when we didn't need to, or we might not arrest you when we should have.
Then perhaps there needs to be more training among officers.
Committee, do you have any other questions for Mr. Stewart? Representative Barrett.
Thank you, Madam Chair. Thank you, Bob. Just to run this factual scenario through you and then tell me if I'm correct, because I just want to verify this. I've never been a records clerk or anything. But if someone is arrested and they're a male, that records clerk is entering that information, let's say in a small rural county. They've entered that information, their biological data, first name, last name, things such as that. That information, that warrant, that's an NCIC now, will never change until that records clerk either clears that warrant out or changes the information within that. And there's also currently no process if someone were to change their driver's license for that small rural county in Kansas to be notified that that sex has changed. Am I correct in that assessment?
Correct, sir.
Thank you.
Do we have any other questions for Mr. Stewart? Okay, seeing none. Thank you so much for being here. We appreciate it.
Thank you, Madam Chair.
Yep. Committee, we have two more proponent testimonies. First, we have Dr. Michelle Ballman. She will be with us on WebEx. And committee, I would just like to remind you of our protocol that we are going to respect our conferees. Okay.
Can you hear me?
We can hear you. We can't see you yet. Do you have your camera on?
It should be, yeah.
Okay, there you are.
Thank
Okay,
you, Madam
thank you.
Chair,
Welcome to
members.
committee. Appreciate you being
Thank
here.
you. Thank you for having me and letting me testify. My name is Michelle Ballman, and I'm a hospitalist physician currently practicing. I've been in practice for 9 years, and I'm at a level 1 trauma center and a level 1 stroke center here in Wichita, Kansas. And I would like to testify as a proponent for this bill, primarily from the standpoint that we do gather critical information regarding a person from the driver's license and from their gender, especially in medical emergencies where said person cannot tell us about themselves. And every doctor that writes a note, in the first 5 words, we always list the patient's age and the patient's gender. And that's been done for years and years. And the reason is because those 2 pieces of information are critical, and they're objective, and they cannot be subjective, because these objective findings lead us to treat a person better. There are differences in medical emergencies and differential diagnosis of pathologies. Gender does matter. It is like a vital sign when treating a patient, especially in a life-threatening emergency. If we were to remove this from the driver's license and change it to a subjective choice that the person is making, you are essentially blinding, emergency responders and emergency physicians. And you take us back a step and we have to then, define or identify what the chromosomal makeup is of the person to help delineate their risk factors and treat them accordingly. This begins, on scene. For example, at a trauma, when the EMS arrive, they gather the information they can, including vital signs and gender and age, and they relay that to the hospital. So this is even starting before a person crosses that threshold into the hospital. The faster we have the information, there's plenty of research to support this. The faster we have that information, the faster we can treat the patient. And I would also state that it affects everyone. So if a person chooses to change their driver's license to a subjective, choice of what their gender is, we can no longer trust this easy and clear, objective information source. So for everyone, for me, if I'm in a trauma and the hospital doesn't know who I am, they don't know for sure if I'm a male or female based on my driver's license. So it just added a whole nother step of diagnosis and testing to my care. So for this reason, I am a proponent of HB 2426. Thank you.
Okay, thank you, Doctor. Appreciate that. What questions do we have for the doctor? Representative Carmichael?
Thank you, Madam Chair. Dr. Ballman, you said that you work at a level 1 stroke center in Wichita where you're a hospitalist. I think that means that you probably work at Ascension Via Christi St. Francis Hospital in Wichita. Would that be correct?
That's incorrect. I work at Wesley Medical Center.
Okay. Okay.
HCA.
I didn't know they had level 1 stroke there. I'm glad to know it, though. Thank
Yeah.
you.
Yeah.
But the second thing, though, is you receive patients at Wesley, where you do hospitalist medicine, who arrive with no ID, no identification at all, no driver's license, sometimes even no clothing.
Yeah.
But somehow you manage to treat those patients, don't you, doctor?
Yeah, it's delayed compared to when we
Thank
do have
you.
Go ahead. You can answer the question. Go ahead.
Oh, yeah, I
If you
was
had
just
something
saying,
else.
yes, we do treat everyone, yes, but it does delay care when we have to find out that information ourselves.
Thank you. Do we have any other questions for the doctor in the committee? Okay, thank you. We appreciate you
Thank
being
you.
with us today. Yep. Okay, and then our last proponent, in-person testimony, Lucretia Nold from the Kansas Catholic Conference. Welcome to our committee. I don't know, you might need to push the button.
There we go. I think that's better. Okay. And good afternoon, Madam Chair and committee members. I'm Lucretia Nold. I'm with the Kansas Catholic Conference, where I represent the Catholic Bishops of Kansas. And we are here to voice our support for HB 2426. I hope by now, or if not, hopefully soon, you will have your my written testimony in front of you. And for the sake of time, I'm just going to provide a brief highlight and summary of that testimony for you here. As Christians, we find our identity in God, our Creator, through sacred scripture, tradition, and science. Science specifically serves as a foundation for our society to function safely and orderly. The examples I provide in my testimony have actually been mentioned here today from the doctors, from the Attorney General, from the KBI, and regarding how it's important to know our biological sex, our biological gender, in order for our medical professionals to provide proper care and treatment and diagnosis for the patients that they are treating. And it's important for law enforcement so they can properly work cases and know how to properly house inmates for people's safety and protection. So overall, it's worthy to note the Catholic Church's teachings on social issues does not contradict science, and nor does science contradict the teachings of the Catholic Church. So with that, we stand in support of HB 2426, and I'm happy to take questions.
Okay, thank you. Do we have questions for Ms. Nold? Okay, seeing none. Thank you, Lucretia. We appreciate you being with us. Okay, committee, we will move on to the opponents of House Bill 2426. I'll first call to the podium Melissa Styler, is that correct? You can correct me if that's not right. And from Loud Light Civic Action. Okay, great.
Oh, is it on? Okay. Once upon a time I was a cheerleader, so I thought I was just loud enough, but Loud Light Civic Action unapologetically supports the LGBTQ+ community, including the right to live a happy, healthy life that is free from government interference in their ability to be themselves in that public life. It's with these values that Loud Light Civic Action strongly opposes HB 2426. So, upon proponent testimony, something that's kind of interesting here, that I'm going off script for, is that this isn't a healthcare bill, supposedly. It's not a bathroom bill, supposedly. It's supposedly not about denying people access to things like domestic violence shelters and other services that may or may not be separated by sex or gender. But that is all everybody had to talk about. So we see where this bill is going. Whenever this bill was brought up in the original version that has been struck down in certain ways, was brought up in 2023, lawmakers promised that it was not going to be a healthcare ban or a bathroom ban or a ban from getting services for domestic violence or anything else. They promised that over and over again, yet that is all anybody could talk about today. So I'm pretty concerned, but I'll go back to some points of clarification. You have my written testimony. I've got an enormous amount of citations that I'm sure all of you are going to read, but I'm going to comment on a couple of things. So first of all, this idea that sex and gender have always been the same thing, that there have always been only two sexes, that science backs this up, is entirely inaccurate. The current definition in Kansas law on sex is completely inaccurate. Just for instance, intersex people. Intersex people are as common as people with red hair. Every single one of you definitely knows an intersex person. You just do not know that they are intersex. Immediately, this definition would remove these people from what is a man or a woman. Despite what, I'm so sorry, I can't remember his name, the plastic surgeon, what he said, 1.7% of people do not have genetic DNA that is explicitly male or female. It is incredibly common. The definition that is already in law, as far as sex is concerned, excludes this entire population. And they're not the only one. This idea that that being trans is this brand new thing, that this whole situation is just this new US problem, is also completely unfounded. Throughout time and history and cultures, there have always been transgender people. There have always been people, and I say transgender as an umbrella term here, not just in the modern US context, but people who are not necessarily biologically or socially or culturally or spiritually recognized as either male or female. This idea that it is one or the other is a fairly isolated worldview. It is not a universal scientific ethical, moral, cultural truth. In fact, today in the United States, there are indigenous tribes that recognize additional genders. This law would violate their religious freedom. Historically, in Judaism, they have recognized more than just male or female. While that may not be the current modern practice, that goes to show that what is new right now in this moment in time is this trans panic hysteria that's coming from a small but very vocal minority of narrow-minded proponents. This idea that only male or female, again, excludes entire populations from Kansas law. Inevitably, that's going to make things hard. It's going to make things hard in the court. It's going to make things hard in their life. It's going to make things hard in their medical files. Inevitably, whenever this goes into what proponents said, a bathroom ban and a ban from domestic violence shelters and a ban from receiving other so-called gendered help that trans people are now excluded from, what about those intersex people? Are they excluded from it too? What about people who are indigenous and are not recognized as male or female? Are they going to be excluded from it too? This is a complicated legal question, and creating what could best be qualified as a middle school definition of gender and of sex as the legal framework of how we in our bodies exist in public life is a foolish pursuit. Now, let's dive into some of this kind of trans panic nonsense that has been brought up. Showing your ID shouldn't actually be a dangerous act, but whenever we have proposals like this, it becomes one for trans people. Transgender people face extensive discrimination and hate-based violence. You need a legal document to vote, to go to school, to open a bank account, to get a job, to get a library card. Whenever you show your ID that does not reflect who you are, whenever you are that big, burly constituent of Representative Carmichael, and you walk in with your giant beard to the library or to vote, and you show your ID and it says F on it, people are going to question if you are being legitimate. It puts them at risk having to out themselves over and over and over again, having an ID that does not accurately reflect what they look like, how they are perceived, how they live in the world, who they are. It puts them in danger. And so the other part of this is this idea that trans people are tricky, which is essentially what our law enforcement officer said earlier, just a bit ago. That bills like this and this bill also, it's based around this extremist conspiracy that trans women are predators. Despite what propaganda influencers have to say on Twitter about this, there is no evidence of that. Any of these examples that have been brought up, the problem is not trans women. The problem is men in all of those circumstances. This would not change predatory male behavior. It doesn't fix it. It doesn't address it. It doesn't do anything to help that. If you'd like to address it, make a law to help deal with predatory men, not to criminalize transgender people. In fact, a majority of sexual assault, mass shootings, violent crime across the board, men. There is no evidence that trans people commit crime at any higher of a percentage than somebody who is cisgender. There's simply no evidence. Again, I've got plenty of research cited in my written testimony, so I hope you see it. Because also the reality is that trans people are over 4 times more likely than the general population to experience violence. This violence has only continued to increase over recent years. What I believe is the FBI has reported that since 2015, hate-based violence against transgender people, just for being who they are, has increased 340% since 2015. Now, this is a pretty alarming rise in violence. And again, Transgender people are the victims, not the perpetrator of this violence. This has become so much of an issue that because state legislatures, such as this one, are passing laws based on propaganda, based on misinformation, based on Twitter conspiracy theories, this national trend of legislating based on this is alarming enough that globally renowned scholars have issued a warning this week that the United States is in early stages of genocide against trans Americans. Now, agree with this or disagree with this, I will tell you who they are and what they say. I'm going to butcher her name, so I'm sorry, doctor, but Dr. Elise von Joden-Forgy is the founder and executive director for the Lemkin Institute for Genocide Prevention. Earlier this week, she is who brought a number of international scholars on genocide together to make this alert. She says that the United States is now in the early to mid stages of a genocidal process against trans and non-binary and intersex people. Among those experts who join her in this warning is Dr. Gregory Stanton, former president of the International Association of Genocide Scholars, who, on behalf of the United States State Department, drafted the United Nations Security Council resolutions that created the International Criminal Tribunal for Rwanda. So this guy's for real, right? I mean, he's the guy who dealt with the Rwandan genocide. And here's what he had to say on the matter. He said, I think what they're doing, as in state legislatures, as in US politicians, I think what they're doing here is they're trying to destroy a gender group. And so I do think it's genocidal. I think the objective here is literally physically to destroy this group. And that's what laws like this do. They aim to erase trans people out of public life, out of existence. This bill does not protect women and girls, and it instead weaponizes civil rights against a vulnerable population. There's nothing in this bill that actually codifies more rights to protect women. It's not about sports, supposedly. It's not about healthcare, supposedly. All of these things that are talked about in proponent testimony, none of that is actually addressed in this bill. It's certainly not about things that actually benefit women and families, such as affordable childcare, paid parental leave, or housing affordability, the cost of food. Instead, it takes rights away from trans, intersex, and gender diverse people, scapegoating them as a problem, whenever they are not causing any of the problems that our women and families are dealing with today. And by weaponizing civil rights terminology such as the Women's Bill of Rights, proponents are hoping to eradicate trans and gender diverse people from gendered public spaces like bathrooms and domestic violence shelters, which of course was discussed by the proponents today. Additionally, this bill does not make any of us safer. It would open everyone up to gender policing and scrutiny, including folks who are not transgender. In other states, laws like this and what is proposed specifically in this law have led to cisgender women with short hair who are unusually tall being turned away from domestic violence shelters or kicked out of a women's bathroom or even opening them up to threats of violence. In fact, an issue like this was brought up by the KBI earlier today. Whenever there is gendered policing, rather than dealing with the individual and having to guess what bathroom they should be in or whatever, people could also just mind their business. Totally normal, non-threatening, non-violent restroom use is not a police matter. Trans people have been peeing forever. This has never been some kind of emergency. You don't need to make it one now. This bill would also harm public safety by threatening unreported crime and lack of cooperation with police and the courts. When a witness or a victim of crime is required to expose themselves to additional harm, to put themselves at risk just by showing an ID that no longer matches who they are, that immediately outs them as being an other, that immediately shows that they are a vulnerable part of a vulnerable community, that a number of people are just so bothered by that they're committing massive violence against them. It has a chilling effect on their ability to trust the police, to cooperate with the courts, to engage with public safety institutions and the criminal legal system in general, even if they are the victim of the crime. This puts a chilling effect on all of our public safety. It leads to increased risk of crime for all of us whenever you have an incredibly at-risk population who is unable to work with the police even whenever they are the victim for fear of their own safety. Now, to the KBI's point, I don't understand exactly how a gender marker would help with the visual ID, but I think that Representative Carmichael covered this pretty well. The entire point of being able to update your driver's license, whether it's with a gender that accurately reflects you at that moment in time, or your picture, or your hair color, or your height, or your weight, is that we change over time. You want to have an ID that accurately reflects who you are at that point in time. I don't still have my ID from whenever I was 16. I hope in my 30s I look close enough to it. But if there were a medical emergency, if there were some kind of situation in which I would need to engage with the criminal legal system on my behalf, I would hope that they had an ID, that they could identify me from that ID based on where I'm at this moment in time. Not that it said that I had a different hair color, or I was 20 pounds lighter, or whatever happened whenever I was 16 years old. I think that trans people deserve that same respect. They deserve to be seen as they are right now. It will make them safer. It will make public safety better for all of us. And so, for this reason, and many more that I thought I wouldn't be able to get to us, so I didn't include it in my testimony, we strongly urge members of the committee to oppose HB 2426. And overall, we urge the legislature to please leave transgender Kansans alone. Time after time, Kansans have said in every poll that they do not want any kind of broad-based discrimination. That's what this bill is. They do not like this culture war nonsense. That's what this bill is. Please focus on the everyday kitchen table issues that we need you to focus on. Please focus on the things that actually impact all of us, not an incredibly small, vulnerable population. They do not need to be attacked by you. We, your constituents, desperately need you to deal with things like the cost of living and focus your attention on things that actually are important to all of us. Thank you so much. Have a good day.
Committee, do you have any questions for Mrs. Styler? Anybody? Questions? Okay.
I'm so glad I was so thorough.
Thank you for being here. Next, we have iridescent rifle. Yes, I'm sorry, we have a question. Sorry, Representative Sweeley. Sorry, I didn't see you.
Thank you, Madam Chair.
Yep.
I was just wondering, when you said you're nonpartisan as a group, right? Can you tell me how many bills you testified in the last couple of years that partisan comparative to the conservative movement? An opponent or neutral or anything like that, or proponent?
You know,
or neutral or proponent, I guess is fine.
I mean, I oftentimes don't necessarily think about, I would have to look at vote counts, but I know that every bill that I've generally worked on, it's never been a explicitly partisan split. The things that we focus on are things that we serve young Kansans. They decide our agenda broadly. So what we generally focus on is, of course, what I believe to be like basic patriotic values of being able to vote, making sure your vote counts, making sure our elections are free, fair, safe, secure. That's our primary thing. That's something that has been supported by Republicans and Democrats and libertarians and whoever. Hopefully all Americans care about that. A lot of the other work that I personally do is dealing with government overreach from the state legislature. Whenever it comes to issues of local control, of restricting freedoms, of that kind of thing, that's something that most Kansans agree on. Basically, all of the things that we testify on are broadly popular according to polling across the state. As far as your individual districts, I can't speak for that, but I don't really think about things in terms of vote counts in general.
Not necessarily vote counts, but partisanship. I think everyone can kind of see that this bill is partisan right now, right?
I wouldn't say that to be true.
Well, the bill
Are
previous to this just passed both chambers with a 2/3 majority, right? So that would
The Women's
both-
Bill of Rights?
Yes.
Sure, and had Republican and Democrat opposition.
1 or 2 members out of 88.
I couldn't say, and also I don't know if how you all vote at the end of the day is accurately reflective of what your heart and your constituents feel all the time. So I'm not going to speculate on that.
Well, in terms of constituents continue.
Thank you, Mr. Representative Carmichael.
I'll wrap it up real quick.
Okay, thank you if you'd wrap it up.
It seems that yourself and, the more commonly person that uses with loud light or talks with loud light are both registered Democrats. And when you guys come into committee, it always seems to be a partisan bill that you're opponents to. How do you, when you differentiate, when you're at?
So I think a comment, but not a question. I think you've had your questions.
All right.
Okay, thank you. All right, any other questions? All right, thank you. Okay, we will now call Iridescent Rifle, Equality Kansas, to the podium. Welcome to our committee.
Hi, thank you. I do have, I'm going to set my cane down here so I don't fumble it. I do have 10 copies. I used to be a teacher, so if y'all would like to pair and share, I can pass copies of my testimony. I've got it right here if you would like it. I am a trans Kansan, so I'm actually going to pass it out and ask that you do read through my testimony since you are supposed to read through it before.
Yeah, just a second. Oh, excuse me, you can't approach the committee.
Can someone come
But
grab
if
these from me?
someone would like a copy, absolutely. Yeah, Natalie, if you could pass out the copies, that would be great.
I appreciate you
Whoever would
reading
like
through
a
my
copy.
testimony. It goes through my life story of what I've experienced, and it's really important that you read it before you make a decision that impacts my life.
I don't think there's enough for everybody. So she's. I'm fine. Okay, why don't you go ahead?
Okay, thank you. Hello, my name is Iridescent Roney. I apologize. I may have put the wrong last name. I got married recently, so I wanted to introduce myself that way. I do use she, they pronouns. I'm here to speak in opposition to House Bill 2426, and I thank you for the opportunity to speak and exercise my constitutional rights. I've appeared before the legislature these last few years to discuss the impacts of other legislation targeting the transgender community. Today, I want to speak specifically about the bill we're talking about today. When our identities are put up for debate, and by our, I truly mean anyone as well, but specifically today, when transgender identities are put up for debate, it removes us of our humanity. Our very existence is framed as something that is optional or chosen, and it is this very debate that has led to mass misinformation to be spread about our community and has led to our demonization. Demonization that guides legislation. On January 5th, 2026, the Lemkin Institute for Genocide Prevention and Human Security warned the world that the United States is in the early stages of genocide. Dr. Henry Thoreau, a former president of the International Association for Genocide Scholars, stated that the kinds of legal shifts that are happening, the kinds of blatant hatred being expressed by Trump and his followers and government leaders, I think we're already at the point for trans folks, for immigrants, where the damage is being done. So it's not so much will genocide happen as we've got to stop it from happening. This last year, I lost a trans friend to violence because of her identity. When I appeared before the legislature last year, I spoke of teenager Brianna Gay, who was stabbed to death by her peers. Peers who were emboldened by anti-trans legislation and misinformation regarding her identity. I hoped such violence would have stopped then. Then I lost a friend and fellow organizer after she was shot and killed for being transgender. In the last week of 2023, Amber Miner was shot and killed in Raytown, Missouri because of her trans identity. In February 2024, Nex Benedict, who was 16 years old, by the way, was beaten inside a bathroom by their peers in Owasso High School in Owasso, Oklahoma. This happens close to home. Every year we gather to mourn those of us killed on Transgender Day of Remembrance. This violence is perpetuated through anti-trans legislation like HB 2426, which aims to erase transgender people. Our ability to live safely and freely isn't woke. It isn't a political game to be won. It isn't a partisan issue. It's a human issue. I'm human. I've been referred to as it by our Attorney General today. I am human. Our ability to live is not a partisan issue. Would you want this to happen to your children? Would you shrug, turn your eye, close your ears, and pass legislation that you know will cause them harm? Or does it require the threat of a Nuremberg-style trial for you to actually understand and care about the sanctity of human life? You can end this cycle, y'all. All it takes is the courage to stand up to the American Fascist Party. For some of you, this might mean voting against party lines. The violence has perpetuated so often from rooms here lead to the death of my friends and my family. A vote in favor of HB 2426 is a vote for complacency in the face of genocide. A vote in favor of HB 2426 is your ticket being remembered as signing our death warrants. And for many of you, a vote in HB 2426 could lead to your own international criminal court hearing. What did you do in the face of the American Fascist Party? Thank you for your time and attention, and I'm happy to stand for questions at the appropriate time.
Thank you. Committee, what questions do you have? Does anyone have a question? Okay, thank you. Appreciate it. All right, now we have Jay Flatland, private citizen.
Hello, can you hear me?
Is that button on?
I think so.
Okay, the light will come on if it's on.
Madam Chair, members of the committee, thank you for letting me speak to you today. I'm pretty nervous, bear with me, I've never done this before.
Doing fine.
My name is Jay Flatland. I'm a dad. My comfort food is sourdough bread that I make for my family. There's nothing that makes me more comforted than knowing my family's taken care of and fed. I have 4 kids. 2 of them are transgender. There's a lot of misunderstanding in what it means to be transgender, and I thought maybe my perspective as a cisgender father about what it's like seeing my kids grow up and be transgender. What does it mean? We all know what gender expression is. We don't talk about it a lot, but it is, you know, for a man, gender expression is like being muscular or having facial hair. For a woman, you know, dressing up pretty or having soft skin. We want these things because our minds are wired to seek that expression, to seek that look. For most of us, that aligns with our biological bodies. But for transgender people, like my kids, it doesn't line up with their bodies. What they want is different than what their bodies are. This is maybe similar to being gay or lesbian, where you might think that our bodies would line up with the wiring in our minds, but it doesn't for some people. I think we all know that for gay and lesbian that's a real thing, and transgender is kind of the same way. You could imagine a teenage girl, if you have teenage daughters, if your daughter started developing facial hair, the distress that would cause her, mortified she would be. Or if you had a teenage son who started developing breasts, how mortifying that would be. He would be horribly embarrassed to show that body. That the way my kids' minds work goes in the opposite direction. And that's just the way they are. Some people have taken the approach that my kids are confused, that they should fix the wiring. There's no fixing the wiring in my kids. So I want to correct that. I hear that a lot, that these kids are confused, or these people are confused. It's not the case. Sorry, nervous. A driver's license is an artifact of that expression. So when my daughter has a driver's license and it says F on it, That's why I'm here testifying against this bill, is because that is an artifact of her expression. That makes her feel good. That makes the trans people I know feel good. That's why. I don't think we're emphasizing enough why people want this. This is why. So I hope that kind of helps. Yeah, so that's kind of my point. I'm not an expert in a lot of things, but I'm an expert in how my kids' minds operate. So if any of you, I can stand for questions if anyone wants to ask questions.
Yeah, you did fine. Committee, do you have any questions for Mr. Flatland? Okay, thank you so much.
Thank you for your time.
We now have Elise Flatland.
Humphrey, members of the committee. My name is Elise Flatland. I am a resident of Olathe, Kansas. I am a mother of 4 children. As my husband mentioned, we have 2 transgender children. This bill aims to explicitly define gender to align with biological sex as it is applied to driver's licenses and birth certificates, thus eliminating the validation of gender identity and transgender people. This is the 3rd year I've been in front of committees here. This is the 3rd year I have asked you to recognize my children as human beings. So far, you've taken away their ability to play in sports. You've taken away their right to medical care within our state. And now you want to take away their identity? When is it enough? What more do you want? It's frustrating, to say the least. My children didn't choose to be transgender. I didn't trans my kids. My kids are who they are. And I let them be. And the fact that you want to change what my daughter's driver's license is, do you know what I went through to get it? Because guess what? We didn't walk down to the DMV and tell them that she was a dragon for her gender. I had to prove that she was a female. So nobody's changing it just for the heck of it. It's work, it's effort. And it's work and effort to be different in this world. And I just want to know, who's being harmed? Who in Kansas is harmed by what gender is on my daughter's birth certificate? Who's harmed by what's on my driver's license? I recently had my first seizure. When the paramedics showed up, I was confused. I had no idea who I was. I couldn't tell you how old I was. And you know what? I didn't have my driver's license on me. They still treated me. They were still able to take me to the hospital and have me admitted based on what my family said my gender was. They didn't check. It's not necessary to treat someone. It's not necessary to arrest someone. It's just not necessary. I'm exhausted. I'm angry. And I'm heartbroken. But I'm also a mom. And I'm not going to stop fighting for my kids. And I'll continue to show up, to speak out, and demand a future where my children and all Kansans can live openly and safely. We deserve a more inclusive Kansas, and we deserve leaders willing to build it. Thank you.
Thank you. Do we have any questions from the committee? Okay, thank you. We appreciate it. All right, we now will have Matthew Obold Gary, private citizen. Welcome to our committee.
Thank you, committee. My name is Matthew Obold-Geary, and I'm a lifelong Kansas resident. I'm in opposition to HB 2426. As we know, this bill would define the term gender in Kansas to mean biological sex at birth and to require state agencies to invalidate and reissue vital records and driver's licenses to reflect that definition. While I understand the bill's sponsors may intend to clarify statutory language, the proposed definition and the administrative mandates that would accompany it raise serious concerns for Kansans, particularly transgender, non-binary, and gender-diverse residents. Firstly, invalidating existing identity documents causes harm and confusion. Requiring the Division of Motor Vehicles and Vital Statistics to invalidate and reissue driver's licenses and birth certificates not only imposes significant administrative costs, but also creates needless stress for those individuals who have lawfully amended their documents under current processes. This could disrupt employment, housing, travel, and access to medical care for people whose lives depend on accurate identification. Secondly, this bill fails to consider the well-being of vulnerable Kansas residents. Transgender and non-binary Kansans already face disproportionately higher rates of discrimination, harassment, and barriers to healthcare. Legislation that undermines their legal identity contributes to stigmatization and can exacerbate mental health challenges. Bills like this send a message that their identities are not respected or recognized under state law. Thirdly, HB 2426 has some practical problems and some legal uncertainty. This bill could create confusion in the legal system, law enforcement interactions, and public services when state documents are altered retroactively. It is unclear how this proposal would impact federal identification requirements, interactions with other states, or situations where legal gender markers play a role in access to services. Reissuing documents on a larger scale imposes unnecessary costs, prompting policymakers to consider fiscal responsibility and the efficient use of taxpayer resources. Reissuing official documents on a large scale would require additional staff time, system updates, and potential reprinting costs. At a time when many Kansans are concerned about budgeting priorities, directing resources toward a bill with no demonstrated public safety or administrative benefit seems unwarranted. For these reasons and more, I urge members of the committee to oppose HB 2426 and instead prioritize legislation that respects Kansans' dignity, protects all residents from discrimination, and avoids unnecessary burdens to individuals and state agencies. Thank you.
Okay, thank you. So committee, do you have any questions for our Representative Bohai?
I actually don't have a question. I just want to say thank you for coming and testifying.
Anyone else? Okay, thank you so much. All right, Brandy Lohman, private citizen. Is Brandy here?
Yes, I'm here. I'm trying to
it's
get the
WebEx.
technology.
Okay, yeah, okay.
Okay.
Okay, we can see you.
Can we hear me?
Yes, we can.
Okay, great. My name's Brandy
Welcome.
Lohman. I'm in my 40s. I transitioned about 8 years ago. I've been on hormones and got my name changed legally about 2 years ago, somewhere around there. I'm a little nervous and kind of lost the vibe. I'm just like a person, and I've seen a lot of people have been testifying from like organized groups with citations, and all I really have is my lived experience of living under SB 180 and seeing us go through all of this stuff again. So my written testimony is out there. I'll just summarize it, and I'm tired. I'm really, really tired. The last 2 years have been exhausting personally for me and for our community, while the course went unreasonably slowly on Harper, but we eventually won. And as the Attorney General noted, the Kansas Supreme Court chose not to pick up the case, which is unusual, but also says something about the merits of this particular case, in my view. But here we are again, and we have so many other things to worry about: property taxes, school funding, affordability, the consequences on rural farms and hospitals, stuff like that, as disastrous consequences to the federal actions in the last year. I find it mind-boggling that this is what the state is concerned with. I checked out this morning, as reported by CNN prior in about 2023 at the very start of the year, 233 people had changed their gender markers between 2019 on the suit and the end of 2022. And the first half of 2023, prior to when SB 180 went into effect, we saw a surge of 161. So if I do the math right, that's just under 400 people, an epidemic of trans people that are just flooding all of our vital records and confusing the state officials. Our state's population, by the way, is about 3 million. So I would do the math and give us the percentage, but it would require scientific notation to express compactly. It's a vanishingly small number of people. So I'm baffled that this is worthy of our time, but when something's important, I guess you make the time, right? My contempt around the politics of all this stuff could fill volume. So I just want to focus on not the bigger issues of transgender identity and these very cerebral concepts. Let's just focus on the driver's license issue alone. If this bill and codifying 180 in a way that makes it legal proof is the goal to eliminate administrative challenges by all the agencies for change gender markers and things that might produce confusion, I'll note that the Attorney General failed to demonstrate real harm according to the court. The best that he came up with was speculation that police might have difficulty in identifying a suspect if their gender markers are different from our assigned sex at birth. And we heard similar testimony from the agent from KBI. I would ask us all to take a walk with me. Let's say that someone with my presentation snatched a purse at a large event, maybe a hockey game or concert at a state fair. And authorities want to announce to the crowd that there was theft and to keep their eye open for a man, 5'11", 190 with blue hair. Should they add maybe that I was in 5-inch heels or had 38 Bs at the time to add to that description? Or maybe convolute this description more with even more qualifiers that describe the typical traits of a woman? Would that produce more confusion and muddle the identity of the suspect me to describe them as a man or the woman in this case? And as I think about like scenarios, any scenarios imaginable where this would be a case, they all trend to the absurd when they're examined with this grain of scrutiny. If an identification document is a tool that's designed to identify, then it should facilitate and not hinder in that singular task. This is my body, it's not a costume. So if I was wearing an M on my ID and the cops were looking for me, I don't see how that's helpful in identifying who I am in a crowd. My life as a feminine coded trans woman with an M on my ID, which was true for some time, did not do a great job of identifying me as a man, but it did a very good job of identifying me as trans. Doormen, clerks, administrators, cops, whenever I've dealt with these people and they took a look at my ID, they have that brief pause when they confront their confusion and then have this realization of what my situation is. It starts to out me anywhere I go. And given how this state and its people seem to feel about us, evinced by bills like these, being outed can be extremely dangerous in the wrong places. I'm not fooling anyone here. Like, my voice is going to give away my transgender identity. And that may be true, but I've been quite surprised before when I deal with individuals that I think know, and they find they don't know. I find that they don't know until I explicitly state it. From a distance, of course, I'm read as a woman. I mean, the catcallers at the gas station will tell you that. They don't need an ID to figure out my case. And I spend a lot of time with other trans women, and I consider myself to be pretty easy to read as trans. But there's so many of them that you would never know, given the kind of passing privilege that they have. My friends in my circle aren't here today because they worried about their career or about being just generally identified as trans, because that is not a protected class in this state. So I guess I'm the only one that was foolish enough to come and raise my hand and be identified as a transgender Kansan. Requiring those people to put an M on their licenses, given their presentations, and frankly, some of their body configurations at this point, does nothing to identify those women as men and everything to identify them as transgender. It might as well be a scarlet A or pink triangle. This bill's license provision serves only to intimidate our community. And it feels like that's the point, isn't it? I mean, I've talked about hypotheticals and used an unnamed third party's experience to kind of help make my case. So here's my own firsthand account. My federal ID, my passport, read F for a significant amount of the time that my state ID, my driver's license, read M. Talk about confusion. Which ID do I use, right? In a federal case, do I use my passport? But when I deal with state agencies, do I use my driver's license? Which one do I present when I fly? And at what point do I commit perjury every single time I use an identity document? Because someone who really hates people like me could just make the claim that I lied no matter which document I use, because the other one will contradict me as an official document. I am disincentivized from using the government because I am disincentivized from using my documents. And isn't that the point? To make trans lives so miserable that we either detransition or avoid transition in the first place, at best, or on the other hand, if we persist, well, we just stay at home and don't participate in society and we don't be seen. One can make the argument that flying isn't required. So if I really don't want to show my ID, then I could just travel by car or do something more inconvenient, but I can still participate in society. That might be fine, but there are other cases where participation is compulsory. And this is where I had my most extreme anxiety about this issue. I received a jury summons sometime in the past 2 years, and I was very concerned that I would end up catching a charge and perjure myself by telling the court that I used one gender marker when one of my other documents said the other thing. Like, my documents don't match, and if I'm forced to perjure myself to the court itself, am I going to catch a charge and eventually be V-coded in custody for it? I cannot opt out of interactions like that. So one might also argue that I was in no danger with jury duty, right? I'm not a legal expert. Maybe there's a process for dealing with this. And to get ahead of my first critics that might accuse me of using speculation to defend myself when I condemn Kobach's use of it in Harper, whether I was in danger or not is irrelevant. The anxieties of navigating life under bills that target us like this are extremely real. And the point is demonstrating to you that this causes harm to constituents. This bill's license prevention does selected, targeted harm to a vanishingly small group of people. And I don't see any material benefit to the state or the people at large. Shame on this legislature for entertaining it.
Okay, committee, do you have any questions for our opponent? Okay, thank you for being with us. Okay, committee, we have 4 written proponent testimonies. I ask that you read those. We also, as you know, have a lot of opponent written only testimony that will be posted as soon as possible. And I ask that you read those to the best of your ability. We also are waiting on a fiscal note for this bill. And so just so you know about that. Well, they said that they don't have the fiscal note yet. They said that they haven't had time to do the fiscal note, is what it said. So, okay, committee, any other questions or closing comments on House Bill 2426? Yes, Representative Carmichael.
Thank you, and I recognize that this is moving very quickly, but do you have any concept as to whether you think we might be working this bill tomorrow, or will we have time to read the 240 pages and other?
I don't feel like it would be wise to work the bill tomorrow. I had intended we might, but I didn't know what the, I didn't know what the situation was
And
going
I
to be.
appreciate you letting me know because it
Yeah.
helps me better manage my time. Thank you.
Okay, and I just was informed, so the fiscal note, they did, because what I saw in my, you think the fiscal note is actually in the S drive, because the fiscal note I read said they hadn't had time, but they did make time. Do you know? Anybody have any idea? Just one sec, hold off on that. It was this, Lene. It says they have 7 days to do it, Yeah, okay, so, yeah, because of those things, I don't intend to work it tomorrow. I feel like that wouldn't be wise for everybody, and so we won't do that. Okay, but anything else? So I will close the hearing on House Bill 2426. Does anyone have anything for the good of the committee? I will just say thank you very much for your patience. I know it was a long hearing. We do have meetings tomorrow and Thursday. I don't anticipate them to be this long, and Thursday maybe just a few minutes, because as far as I know, we'll only do bill introductions on Thursday. So, okay, thank you very much, everybody. We're dismissed.